Today, we're going to talk about what it really takes to get a patent. At our firm, IP Boutique Law, we kind of flip the whole process on its head. And our entire approach is built on one simple but, honestly, game-changing idea. What if your attorney was a former patent examiner?
Just think about that for a second. What if you could sidestep all the usual hurdles, all the back and forth, because you knew exactly what the person on the other side of the desk was trained to look for? Well, that's the very advantage we're breaking down right now. So let's get real. Why do so many patent applications hit a wall? It's because, for most people, the process is a total black box. The U.S. Patent and Trademark Office, the USPTO, has this incredibly complex system, and it trips up even really seasoned attorneys.
And here's the absolute heart of the matter. Most patent attorneys, they learn the rules from the outside in, often through some pretty costly trial and error. Our whole perspective is different because we learn the game from the inside. We used to be the ones making the calls.
And listen, this isn't just some marketing line. Our entire practice is built on a foundation of over 25 years of direct, hands-on experience as a USPTO patent examiner. That means we've seen thousands of applications, from every angle, across all kinds of technologies. We've seen what works, and maybe even more importantly, we've seen what fails.
So what does all that time on the inside actually get you? Well, you start to see the patterns. You don't just understand the rules on the page, you understand the mindset of the person who's going to be judging your invention. You just know what makes an application clear, strong, and ultimately get that stamp of approval.
These right here, these are the real-world mistakes we've watched torpedo applications time and time again. Arguments that just fall apart, really flimsy prior art searches, claims that are way too vague, and, oh, a big one, ineffective responses to office actions. That's the official rejection letter from the patent office. These are the exact traps we know how to spot because we've seen them from the other side.
And once you understand that, it completely changes the game. A lot of attorneys think patent law is a fight, a battle of arguments after you get a rejection. We see it as a puzzle. It's something you solve with meticulous preparation before you even file. The real work, the stuff that actually gets results, it all happens before that application is even submitted.
This proactive mindset is everything. We don't just file an application and wait for an examiner to find issues. No way. We essentially become the examiner from day one, scrutinizing every single detail and making your case stronger before it ever lands on a desk at the USPTO.
So here's how we actually put that into practice. We start with a super deep dive into prior art to head off objections before they happen. Then, we review your application with the same critical eye an examiner would. From there, we systematically fix the weaknesses we find, building a rock-solid case from the ground up.
It's really a partnership. Look, you are the expert on your invention. There's no question about that. We're the experts on the patent system. When we combine your technical genius with our procedural know-how and keep the lines of communication wide open, that's when we create the strongest possible application.
So where do we fit in compared to other law firms? You might think your only choices are a huge, impersonal firm or maybe a solo attorney who's stretched a little thin, but that's not the whole picture.
Let's just lay it out. With big law firms, sure, you get experience, but you might be working with junior associates through layers of staff. With solo practitioners, you get that direct access, but their resources or scope might be limited. We're in that sweet spot. You get the deep expertise you'd expect from a big firm, but with the direct, senior-level attention of a focused boutique practice.
So what's the bottom line for your invention? What does this all mean? It means your patent application stops being just a legal document. It becomes a strategic tool, built from the very beginning with the examiner's point of view baked right in.
And we're all about being upfront. We're going to give you a sincere assessment of your invention's patentability and set some realistic expectations. Our goal isn't just to file a piece of paper, it's to build a real, long-term strategy that actually protects your innovation.
So you have to ask yourself this. When it comes to protecting your most valuable ideas, are you working with an outsider who's trying to look in or an insider who already knows the way?